All right. Wayne, did you want to go ahead and make your comments now?
Well, I just like your three-letter agency term.
I actually got that from Chris.
Yeah. Well, it's the idea that you're throwing humor into something that's been a nightmare for so many people for so many years.
I know it.
I have been off the IRS contribution team for most of 35 years. And I learned that from Cleon Skousen. And once I got out of the Air Force and did a few other things, in fact, while I was still on there, I learned that you can take your IRS contributions, put it into a separate fund to take trips. We fed our tax monies into a fund and took all of our real estate agents to Fiji. Instead of paying taxes, we took a benefit instead of being screwed. And so anyway, but since I've gotten into this, I'm going to call it freedom movement because basically it's freeing us up. And Kelby, it's good to hear your voice on here. I appreciate you. I appreciate all the help that you and Fred and Nina, and Keith. There's just a gob of people that have helped me get where I am, and now I'm able to help others. And it is so good to be in a position of helping others rather than wondering what is going on. And so anyway, moving on beyond that, if you study commercial law, you don't need to have anybody contract with you that you don't want to contract, and that includes that funny agency that you referred to. You only, part of commercial law is that you have to be a willing participant. If you're not a willing participant, it's not a lawful contract. And there has to be there has to be full disclosure. There cannot be any of this lack of full disclosure stuff. And you know how much the IRS hides stuff, keeps you in the dark. You cannot contract with the IRS lawfully anyway. Even if you wanted to, I don't think it would be possible. So you do not have to contract with the IRS if you don't want to, and you have the freedom of contracting wherever you want. So to me, it was fearful to break away from the IRS at first, and then I had a strange experience. I let a friend of mine use my name and run a business because he had run out of rabbits to pull out of his hat. And economy was bad here because of Carter putting everything in a jam. So we all took off and went to Alaska, and I let him use my name because, like I said, he'd run out of rabbits to pull out of his hat. And what I did not know is that he was not paying the bonding company, and he was not paying the IRS. He was sucking all the money in under my name and putting it in his pocket, and ran up a $65,000 bill with the IRS on my name. And not knowing everything then that I do now, I went on living on the lam, as people call it, and I was out of sight for 10 years to keep from being hassled by them. And I would get mail once in a while letting me know that the IRS had an outstanding bill with me, anyway, they were wanting $65,000 out of me, and I just burnt them. I never had to sign for those letters. They just mailed them to my P.O. box. I burnt them. And then I just stayed on the lam to stay out from under this character. And since then I have learned that, and this is because of Hartford Van Dyke, if you are not a willing participant in a contract, it is not a lawful contract. If you are not getting everything fully disclosed to you, it is not a lawful contract. If you are signing things and you are under the age of majority, which is 18, it is not a lawful contract. When did you get your driver's license? All kinds of stuff. There's just all kinds of fraud that is involved with this corporation that's feigning to be our government. So if we act lawfully, we do not need to even engage with them. And what I'm trying to do is let people know that you do not have to live in fear. I have willfully, what do you want to call it? Anyway, I have not engaged in contracts with the IRS for most of 35 years, and I'm still living, and I'm not in prison. I do know people, some of the people who have helped me, some of the people who, I hate to say it, some people are out of prison now, some people are still in, and I am very loyal to them and the help they have given me, and I will do my best, whatever I can, to help them whenever they need it. There's not much I can do while they're locked up, but but the people who are being locked up for the most part are either being locked up to keep their mouths shut so they can't help other people, or they are people who have been lied about by the IRS, people who have contracted with the IRS and the 1099s or whatever. I'm not even familiar with all those numbers and what they mean. But people who have signed these 1099s and tried to be lawful with the IRS are now sitting in prison. And that speaks real well for the IRS as far as I'm concerned. They don't care how lawful they are. If they have or how lawful you are, they may not act lawfully with you. And so what I try to present is for people to know the law. If you just know the law, you can protect yourself and stay out of harm's way.
And that's what we're going to go into here. Let me see. Do we have Dave on the line?
David Merland here.
All right. Very good. I think he just kind of laid the foundation for you to walk right in. What do you think?
Good. But, basically, if you just don't contract with them, then you're out of harm's way. Basically, the people who get in, I'm not going to say, for those of us in the patriotic movement.
Wayne. She's trying to transition to the next one.
Let me move in if we can, Wayne.
Well, anyway, I just wanted to get across that those who get in trouble with the IRS, for the most part, are people who do contract with them and then try to get out.
All right. So thank you for that, Wayne. Dave,
right.
Welcome to our call. You're a first-time guest, and we're so glad to have you on. Dave Merland, everyone, and he came so highly recommended. Then I had a great conversation with him today, and if I hadn't have been so busy, Dave, I probably could have kept you on for about 5 hours. So you had great things. Your website, let's go ahead and put it out there, is wevgov.com. W-E, V as in Victor, Gov.com. If folks want to bring that up and take a look at it while you're talking. Dave, tell us a little bit about yourself, and let's get into that three-letter agency. And then you can take this call wherever you want.
Okay. Who was the gentleman that was just speaking?
That was Wayne.
That was
me.
Wayne, yes.
What's your last name, Wayne?
Bachman. Am I on another list now? I know I'm on list. My information's on computers that have been stolen by 15-member SWAT teams. So I'm on list.
My name is David Merland. Nothing you'll hear me say is intended as legal advice. Anything that sounds like that to you, just consider it something somebody else might do on a planet far, far away where the law matters. It doesn't matter here. I prove it on a daily basis. Believe it.
Okay.
In 1988, I was the world's fastest bartender, 6'3", wiry, thin, long arms, real big hands, and photographic memory. And so I was just made for high-volume bartending. I could slam dunk basketballs, so you're not going to beat me around the bar. And
you're talking about that kind of bar. I thought you were talking about alcohol.
Yeah, bartending. And
all right, go ahead, David.
The volume of bartending, the volume bartending I was doing was the scariest bartending you could imagine. You picture a guy with 3 waitresses calling in orders all night long and customers 3 deep at the bar with the band playing, and I thrived on it, where I used to drive to work every night hoping that we got absolutely buried because nobody was faster behind the bar than I was. And Friday and Saturday nights in 1986, I was making $1,100 worth of drinks an hour. And then in 1988, the IRS knocked on my door, and I didn't like the way I was treated. So in June of 88, that's 27 years ago, this month, I began to read tax statutes. I'd never looked at any laws in my life. And 5 or 6 years later, I made several appearances as an expert witness on the content and intent of the tax code. And in 1994, I essentially completed my treatise on the differences between the tax code and the Internal Revenue Service from a standpoint that no one else is familiar with and no one else uses, and that is the standpoint that the government is correct when they say I'm a citizen of the United States. And when I'm a citizen of the United States, I've got so many protections in the tax code it'll make your head spin. And my first primary specialty and expertise is statutory interpretation. Those 6 years were spent analyzing tax statutes and regulations and comparing them to the IRS's standard operating procedure. And I found many statutes that contradict what the IRS says it can do. And when you find that, you read the regulations to find the regulation they wrote that says, we can do this over here. And it destroys a statute in the process. So I compiled a list of instances where the IRS was fudging on the tax code. And to the top of the list over time rose the arguments that do the heaviest lifting. The 2 biggest questions ever asked about the tax code are, does the tax code apply to citizens of the United States? And secondly, when I perform personal services, does the tax code impose a tax on my compensation? Those 2 arguments are to be those 2 questions, are to be answered in very particular ways with a strict adherence to the traverse that I am a citizen of the United States. When you argue from that posture against the tax code being imposed upon you or you being subject to the tax code, you have enormous arguments in your favor using strictly tax law. So I argue from a standpoint that is not shared by anybody in the quote-unquote movement. I spend a great deal of time and energy discrediting the movement. All of these teachings, curriculums, websites, courses, seminars, they're all taught from the presumption that enforcement is legitimate. And with the presumption that enforcement's legitimate, from that flows many more presumptions, such as I must have assessed myself, I must have volunteered in, I must have signed a contract, I must have used the zip code, I must have registered to vote, because somewhere I waived all my rights and I became a federal employee, or I took a Social Security number so I reap a benefit, therefore I owe a duty. All these presumptions are based on the first presumption, which is enforcement is legitimate. You presume enforcement is legitimate because you don't have an understanding of the tax code. When you understand the tax code, you understand they're misenforcing it in these ways. And I got a list of about 22 different angles on the tax code that constitute misenforcement. And the heaviest lifting arguments come to the top as the ones that do the most damage. That damage takes the shape of the IRS shutting down criminal investigations and the Department of Justice abandoning grand jury proceedings. More than a dozen people have prevented their own indictment by following my approach to challenging the government using just the tax code, and no one else can claim that level of success. Whereas there's a team of attorneys, a duo, Mins and Arnett. Mins and Arnett in 2015 have 9 acquittals in criminal tax trials. That's an outstanding record of performance. 9 acquittals just this year. But when you look at that and call it a victory, you understand that a victory, okay, that's when I get indicted. That's when, if I can't afford Mins and Arnett, I'm saddled or strapped with utterly incompetent public defender that has no working knowledge of the tax code whatsoever. And my reputation is ruined. I might be held in custody pending trial. And so I'll be sitting on a bench all day waiting for the right time to call somebody at 21 cents a minute on the outside and ask them how my attorney's doing. And I'll be wearing boxers that are 4 sizes too big in an orange jumpsuit in some federal detention facility, or they might release me pending trial. When my reputation is shot, I'm going to lose all the money that I have because I got to spend it on my own defense to avoid imprisonment. If I can afford Mins and Arnett, I'm guessing I might have to pay $50,000 to $100,000 to get them to go in and go to bat for me in a criminal trial. And then at the end of all that, when they've argued their best that this person, my client, this person doesn't believe he has a duty, and so he's not willfully in violation of the law when he failed to file or failed to pay. And so he's not guilty. He's not willful. He doesn't believe he has a duty. At the end of that argument, you have your future flapping in the breeze in the hands of and under the discretion of a team of strangers that are the criminal trial jury. And you sit on pins and needles waiting for the decision, and they finally come back and say, oh, not guilty. In an extremely small percentage of the time. The government wins all the time. And the acquittals are as rare as hen's teeth. And so, did you really win? Yeah, you got acquitted. That's a victory to a degree. But when you compare it with this scenario, I failed to file or I failed to pay what the government says are taxes, and they've convened a grand jury against me, or they've started an IRS criminal investigations, and we know where that leads to the grand jury. So I better photocopy this criminal complaint that was served on 80 members of Congress January 1st of 06 and supplemented last August and supplemented this February. I've looked at those findings. I've read the arguments in a criminal complaint against the Secretary of the Treasury, the Commissioner of IRS, Tax Court Chief Judge, U.S. Attorney General, and a couple of assistant U.S. attorneys and a couple of judges. I've read those arguments, and, I think that the IRS is committing crimes in their standard operating procedure, and I think they're conspiring to put me in prison falsely. I hereby join that complaint as a similarly situated witness and or victim of crime as alleged in the complaint. And then I photocopy that complaint and my affidavit of joinder, and I serve it on the assistant U.S. attorneys that are prosecuting or that handling the grand jury proceedings against me, or I serve it on the IRS Criminal Investigations Division agents, the successors to Joe Bannister. And in more than a dozen instances, when somebody does that, subscribing to these particular statutory arguments that do the heaviest lifting, we've watched criminal investigations closed down and grand jury proceedings abandoned, the latest of which was January of this year.
Wow, nice.
Which one is a victory? I wasn't arrested. I wasn't fingerprinted. Instead, they abandoned the grand jury proceedings against me. That's a victory. The other one is just a close call.
Question I have is, were you compensated for the time they consumed out of your life?
What time is that?
No, what I'm saying is, if you got drug into court or whatever, you've had to spend some time on these efforts.
Well, of course, that's a criminal trial, and if you win, it's an acquittal. And what you have to win on to get compensated is a lawsuit for malicious prosecution, and you might argue that under the Federal Tort Claims Act. But that's over and above really the topic of discussion today, which is defense against what the IRS claims is your duty under the law. And as we saw today in the Supreme Court ruling regarding the health care bill, the law will be twisted by the Supreme Court too. So suing for compensation is the least of your worries. Stay the hell out of prison. That's the main thing. The main objective, keep your liberty, and in the meantime, you spread the truth that helped you avoid prison to say, here's how the law protects you. And here's the way they're stealing from you. Here's the briefing of it. You don't have to write another brief. You don't have to write another criminal complaint. You simply join the existing complaint that's already part of the congressional record in front of 80 members of Congress, and that makes it your complaint and your brief, and you wield copies of it instead of writing your own complaint and your own briefing. And these particular arguments, which I have not described yet, answer the two questions. Does the tax code apply to Americans, and is there an income tax imposed on the fair market value of services actually performed?
Do you have a copy of all of this on your website?
Are the Kennedys gun shy?
Say that again?
Are the Kennedys gun shy?
Oh.
Meaning yes.
Yeah.
There is a products page on wevgov.com where I suggest you begin. If you're not going to get more than one item from my products page, start with the videos on flash drive. You plug it into your computer, and you'll open a folder. There will be a file and a folder. The file says, open this first, and the folder says, don't open this. And so you click on the file, and it opens up just like a website on your computer, and there will be 2 documents in PDF that you print out. Those are study guides to use while you watch 7 video segments, a total of 3 hours, 45 minutes of instruction, seminars I taught here in Seattle to a small group of students that I can't reshoot with the quality that I had in 2003. The information was right on the tip of my tongue. It flows out of me like water from a fire hydrant, and it's a totally concise presentation of the key aspects of the tax code that show you the most about how the IRS is in free-form enforcement of the tax code. The videos, I look at the tax code from 7 different angles, and each segment is from a different angle. And there are certain arguments that are small. I can count pennies that they're stealing, and I can prove they're stealing everything and everywhere in between. So get the videos on flash drive. If somebody says they know what the tax code's all about and they're not using a diagram to illustrate it, they don't know what they're talking about. There's a certain internal operation of the tax code that until you know it and understand it, you don't know what the tax code does, what it's supposed to do. If all you looked at was law, everybody lets the IRS's standard operating procedure into their thinking, and it influences their conclusion. If you look strictly at statute first, then you look at standard operating procedure, you understand the procedure to be lawless.
Wow, okay.
And all of this sounds very serious. I didn't want to know any of this. I was happy as a bartender in 1988, and I had studied a bunch of real estate seminars and memorized them. And I was looking for a foreign manufacturer for a chair that I was producing in my own wood shop that I had in 5 furniture stores here in Seattle. And the IRS found me, ticked me off, and it totally derailed my life into the study of law. And here I am 27 years later. I'm 5 for 6 against the State Attorney General of Oregon. The U.S. passport application was amended because of me. 2 Treasury regulations have been amended because of my efforts. IRS Publication 17 was amended because of me. And I don't hesitate at all when the government wants money. I can prove they're stealing it 99% of the time.
Exactly.
Any questions or comments on that part of what he just talked about?
No, he's right on.
Anyone?
And then it's a matter of proving it. You don't hear me arguing against property taxes. The Federalist number 12, I think it was Hamilton that wrote it, he laments that the type of government they envision requires, sadly, that the taxes fall upon the land at the state level. And so unless I have a clear statutory argument against property taxes, I leave those alone. It's constitutional. It's a concession that the framers made in the type of government they envisioned setting up for all of us. And so I don't do property taxes, but I do motor vehicle code, federal income tax, and state income tax. Those three, I have arguments for all of them. In fact, I'm going to jump the gun just a little bit to tell your audience that at wevgov.com, on the state income taxation page, you're going to find a whole bunch of statutes, state by state. Most recently, I added Rhode Island, Virginia, Massachusetts, and Wisconsin. State by state, you have statutes that say let's say, for instance, your Colorado adjusted gross income is your federal adjusted gross income. Well, if I can prove when you sell your labor there's no federal adjusted gross income, I pretty much killed state income tax too, didn't I? And so New York, all these states you'll see on that page have a nexus to federal Internal Revenue Code statutes or format. And when they tie it to the Fed and you disprove the Fed, you've disproved state income tax as a collateral benefit. So the findings that I use, and we'll get to those in just a minute, are profoundly basic. They are statutory and irrefutable. August 2nd of 2005 was pretty much the conclusion of a civil suit. A man contacted me in spring of 2005, and he says, I never heard of you before. I just heard your name from a friend of mine. He says, you do dynamite work. I might be indicted for willful failure to file. Any ideas? And the first thing I asked him, I said, how would you like an exhibit that proves you sued the United States for proof that the tax code applies to Americans and they can't debate you on 3 or 4 statutes? He said, let's go for it. So I wrote up a lawsuit under Court Rule 27, action to perpetuate testimony. It's just to open up a docket number and gain discovery rights. And then I included a briefing of 3 statutory issues. And under each issue was questions for review. You got to answer these questions to disprove the conclusion. If I'm wrong, tell me this, tell me that. And there were 3, 4, and 5 questions. 12 questions total under the 3 briefed issues, A, B, and C. And instead of coming into court and disproving the arguments, Assistant U.S. Attorney Stephen Bass asked the court for a protective order against the 12 questions. And the judge, Lee Yeakel, issued the protective order barring the plaintiff from asking the government about those 3 conclusions. Took Congress right out of the courtroom, didn't they?
Yeah, they
did. And so that protective order was the exhibit. I promised him it was the first document to come out of the court, the exhibit that proves he could sue the United States for proof the tax code applies to Americans, and they can't debate him on 3 or 4 statutes. Magic. And that protective order was exhibit number 1 in the 180-page criminal complaint briefing and exhibits that I filed with 80 members of Congress January 1st of 2006. Exhibit number 1 was the protective order, and this gentleman was one of my original co-complainants on that criminal complaint. One other complainant in 1973 had become a self-employed accountant and an enrolled agent to the IRS, and every year he took his tests to maintain that status so he could represent people at audits and in tax court. And he co-complained with me under penalties of perjury accusing the highest of government officials, everybody involved in the enforcement of the tax code, of conspiracy against rights, extortion, racketeering, and a few other criminal statutes. So I have the people with the highest of qualifications verified everything in my treatise and co-complained with me to 3 committees and Ron Paul on January 1st of '06. So this is nothing new. It's all really very old. I'm hardly a beginner, and nobody's heard of me because everybody's heard of the movement. They're the ones with the bullhorns. They're the ones with thousands of dollars to spend on their websites, and they got a really bad attitude about anybody that's not singing a song of sui juris to the third power and sovereign citizen and all the rest of the good garbage that comes along with these theories that frankly are the cause of a lot of people going to prison, and only when these people have been indicted for filing the Form 1040 OID or 1099 OID and these other schemes cooked up by people with presumptions only when they're in trouble do they find me. And so I've dealt mostly with the victims of the movement, and I've not caused anybody to go to prison. I've prevented many people from going to prison. I'm at the opposite end of the learning curve from the ignorance of the law school called the Patriot Movement.
So
well,
you
to
mentioned
each their own on that comment.
I'm sorry?
Nothing. Go ahead.
You mentioned that you're dealing with the victims. What can people do to be proactive right now? They just flat aren't paying, and the IRS is probably going to come after them, but hasn't said anything yet. What should they be doing?
Well, as I stated, I concentrate mostly on preventing an indictment. The difference between preventing a lien and levy and preventing an indictment is that in a matter concerning criminal charges, a conscience is present. It's called the grand jury or the criminal trial jury. It's not a pack of racketeers and extortionists. And the government can't defeat the jury. When you get a real plain argument in front of the jury has control of the verdict. And when the government loses a case, the press is terrible. All the jackals and hyenas in the Patriot Movement come out and throw stones and get their bullhorns and laugh the government into a corner, and they email the transcripts of the trial all over the country. And so every time the government loses a case, it's bad press. And so they avoid losing a case. When you have a posture that would be terrible if you presented it to a trial jury, the grand jury proceedings are abandoned. So I don't do liens and levies because there you can't exploit the fact that you have rights to a jury trial. That only happens in criminal cases. There is one guy here in Seattle who has actually gotten some liens lifted from real estate and the return of Social Security benefits that were levied by using my materials, but it's work I really don't have the inspiration to do because it's so many times futile to prevent a lien or levy at small time, and I really gravitate toward the criminal side, which has helped a lot of people need also. So it's not like I'm idling. I just really narrowed my focus to include only criminal proceedings. So if somebody's out there and they have not filed or have not paid, I've seen people indicted for merely that. And if you feel that you want to hedge against being indicted or even investigated by the Criminal Investigations Division, that's one thing. But I'm not saying I can prevent them from taking your money. You got a government that's willing to spray an entire region called Iraq with depleted uranium ammunition with full knowledge it's going to kill generations of babies in the womb. You think you're going to prevent them from stealing from you? So we have to be realists. And so criminal proceedings. If you don't believe you have a duty, you're not willful. If you can prove you don't even have a duty to believe in, you're worse than not willful. You're absolutely, we can't talk about it, close down the grand jury, we're going on to the next fish, we'll fry somebody else. That's the situation I create. So if somebody thinks that they won't be indicted, you're next. And if all you have done is fail to file and fail to pay, I've seen people go to prison for exactly that. If you want to hedge against the likelihood of an indictment in the future, learn a couple of arguments, just 2 arguments, which I'll outline next. With these 2 arguments, you have willful failure to file, willful tax evasion. You have to meet all essential elements of a criminal statute to be guilty. Willfulness is a 3-pronged test. You have to have a legal duty, you have to know and believe you have the duty, and you have to fail to perform the duty. Everybody else attacks prong number 2. I don't believe I have a duty. I've got a long correspondence record with the IRS challenging their authority, and they never disproved what I was saying, and so I don't believe I have a duty. And you have acquittals for Lloyd Long, John Cheek, Bernice Kuglin, Joe Bannister, and Tom Cryer. I'm not willful. I argue the first prong. I don't have a duty to believe in. You're violating the law in this way and this way, or you couldn't even speak to me. That's way different. That comes from an understanding of the law and having made no presumptions about enforcement. You study the law first, and you see they're violating these 5 statutes to speak to an American who has only sold their labor or reaped capital gains. There. That's 99% of the slaves.
Say, Dave?
Yeah.
Isn't your willful argument tantamount to challenging the mens rea, the mind of the thing, and therefore the intent aspect that's implied by challenging it on its basis for no foundation?
Yeah, willfulness is the equivalent of scienter or mens rea, which means an intent to break a known legal duty or violate a known legal restriction, criminal intent. The Supreme Court just came out with a decision at length based on that tenet of our legal system, that you have to have criminal intent. It's not often written into criminal statutes, but it should be presumed to have to be an element of every statute. This was the Alonis decision, E-L-O-N-I-S. A real nasty dude had placed on, I think it was Facebook, on his Facebook page about his ex-wife that, I'm going to watch you die of 1,000 cuts, and I should take a shotgun into a kindergarten class, and all kinds of really nasty stuff. He was indicted and convicted under Title 18, Section 875C, transmitting an interstate threat to injure or kidnap the person of another. In the Supreme Court, they said the jury instruction on the, I can't remember what circuit it was, the jury instruction was deficient. The jury instruction was that if the person reading it reasonably believed that a threat to do bodily harm or cause death was issued by this person, then you have to find him guilty. And the Supreme Court said, no, you first have to prove that it was made with intent to break the law, and that mens rea is a cornerstone of every criminal statute. In tax statutes, it's called willfulness. To have a legal duty, know and believe you have the duty, and fail to perform the duty. That's how tax statutes identify the mens rea element of the criminal offenses, whereas plenty of criminal statutes don't say that you have to have acted willfully, so the Supreme Court articulated that that standard is in every one of our criminal statutes. And this decision came out only probably 3 weeks ago.
Does that answer your question, Chris?
Oh, absolutely. And I must say that Dave speaks with a tone of authority and knowing in his voice, and it's hard to reckon and dispute that, and that's really what you have to be. You have to be self-confident that you know better than they do and are able to articulate it with specificity. And I compliment Dave Merlin for knowing those things in that manner.
Well, you can learn law from a lot of different sources, and you can't always tell that it's accurate. And I learned that early on. In 1992, I saw nothing but frivolous tax return filing penalties raining down on everybody, $500 a pop. And I thought, I don't need this. And so I turned off the movement and went to the books and never left. I've read easily in excess of 4,000 decisions, most of them federal appellate and federal Supreme Court decisions. And if you were to ask the question, gosh, I wish there was thousands of free law seminars out there that I could take. It's called case law. You can't read too much case law.
I agree.
And after a time, you might even get good enough to say, this decision just rendered is bogus because it conflicts with all these others. And that's what they did today in that decision about the health care bill. They
Absolutely.
set aside the language of the statute. They set aside the language of the statute to say, oh, it includes a federal exchange too. And when you compare that to the void for vagueness doctrine, which says the individual of ordinary intelligence has to be able to understand a statute, especially a tax statute. And then you look at this one that says the subsidies are available for insurance policies purchased on an exchange established by a state. And the Supreme Court says, oh, that means state or federal government exchange. Wrong. The statute says one thing, not both things. And they just set aside all of the case law in the past where they said statutory language is primary, and if it's unambiguous, it stands. We're just judges. They set all that aside so they could accomplish the president's agenda. It's astonishing to see this. Now,
it was a political decision.
That's right. That's all it was. And it was totally in violation of the separation of powers doctrine. But when you've read case law and watched how the government argues it and argues against it when you use it in your favor, you come to understand there's a fabric of due process and American jurisprudence. And then you can not only understand the issue in front of you, but you can look out and go, you know, I learned of this statute or this standard in these cases I read, and now I see government over there on that guy's property behaving in a way that I think this standard says they can't do that either. And you start applying it, and you understand there's a real bona fide American fabric that's unique to this country. And there are precious few individuals out there prepared or knowledgeable enough to even defend it in the least.
Well, here's a question for you, if you don't mind.
Go ahead.
Your ability to perceive, read, and grasp the meanings within this law is so well developed from what you've gone through fighting some of the most insidious criminals in government. It would seem a very lucrative and rewarding step to consider some of the things that we do on this particular call and the fighting against third-party debt collectors and the racketeering done by these criminal banksters who masquerade as lenders when they're actually investors, gamblers, or wagers and have no economic interest in the case and therefore no standing to be in the party, and that constitutes racketeering just like the IRS. And
well,
it has a reward.
Yes. You said criminal bankers. You have a bad attitude.
Well, it's accurate, but it may be bad.
No. When someone says the word criminal, I ask how high. It's just like when somebody says jump, I say how high. Is it a felony? That's the first question I ask.
Absolutely.
When somebody says something was criminal, and here's the reason. Go to wevgov.com and go to the citizens arrest page, and you'll see cases cited from First Circuit through the 10th Circuit, the D.C. Circuit, and the Supreme Court that say citizens arrest of a felon is lawful.
What's that website,
and
please?
So when there is a felony that's been committed, if the suspicion is reasonable, the felon can be arrested. You go to your state law on rights to use force, citizens arrest, and find out, like in California, you got to call the cops first. So I don't know what it is in your state, but in Washington state, the felony doesn't even have to occur in my presence. If I learn of a felony and that person can't even deny it, I might arrest you. And so, first things first, you're a criminal banker. How criminal? If it rises to felony, I would say, you know, I'm going to take out a website with your picture on it and your bank on it, and the least that your company is going to do is relieve you of your branch manager status. But I'm going to urge everybody in this neighborhood, in this community, in this county, whatever, to arrest you at home or at the meeting where you're in front of all your peers, at the presentation of the awards for being the most lucrative or whatever. Do you have anything you can do that might impress upon me that I've misjudged your character at all? Do you have anything that you could, any gesture you could make toward this woman who lost her house in that foreclosure proceeding to convince me that you didn't commit a felony against her when you foreclosed? Like, give her house back.
This is something
I got dominion over every pound of flesh they own when they've committed a felony. And so if you have a gesture you could make, an overture that you can display that would convince me that I'm really wrong when I paint you this way, now's the time, because we're gearing up to arrest you. See how that took place without the cops, without the courts, because we know they're bought and paid for, and yet I stand in front of somebody over whom I've got supreme dominion. How do you like me now?
Yeah, this is something that Steve Curry has been pushing for us, to have a wall of shame to expose all of the criminals in our public service.
It's one thing to expose them. It's another thing to stand in front of them and say, you're under arrest. Yeah. Prove me wrong, or up against the wall and spread them.
Tell us what the website is again, please.
We, VGov, as in we the people versus government, wevgov.com. And the information on the website is very dense. There's nothing on the website you don't need to know, and there's everything on the website you need to know for a few key points, which are the two largest, the heaviest lifting arguments against the tax code and state income taxes, and the motor vehicle code, to prove it's all felonious misenforcement, which means it equates to the right of every citizen to arrest just about every damn public servant out there except the dog catcher.
Right, right.
Do you want to get into the motor vehicle code?
After the tax code.
Okay. Definitely.
And you might have heard me sneeze just a minute ago. I have to take a short break and blow my nose. I'll be right back.
You're good. Thank you. Anybody want to talk about?
Well, Dave is away. He's I'm pretty sure I recall him being affiliated with Lewis Ewing up in Washington State, who is a tribal lawyer who has a lot of wonderful law citations, information, fights against CPS, DCFS, fights against the state, motor vehicle things also. And, you know, I have to tell you that Dave is a much more palatable and easy to listen to educator in that aspect. Lewis is just a little bit rough around the edges, being a former professional fisherman in his life, so he doesn't have quite the professional, courteous speak that David Merlin does.
I'm back.
Good. Thank you for that, Chris. Go ahead, David.
Did you just make reference to Lewis Ewing?
I did.
Yes. I call him a friend, and today coarse language was the rule because of that Supreme Court decision. I was a bartender. Make no mistake about it, I got a vocabulary as bad as anybody out there if I wanted to use it.
Absolutely.
But when it comes to research, my hat is off to Lewis Ewing. The guy is a research. He's a slave to research. And he has done to the motor vehicle code what I did to the tax code. So my hat's off to Lewis Ewing, and for his rough edges, he does have the research background. So that having been said, tax code on wevgov.com. As you look at the home page, there's a mission statement on the home page. You can either read the mission statement or click on the audio link and listen to me read the contents of the home page. And then you click on Enter, and it'll take you into the website. On the left-hand side of the menu column, On the top left of the menu column, or in the menu column, at the top is a link that says YouTube 2. Click on YouTube 2. It'll take you to my Take From Caesar YouTube channel that has a bunch of free seminars. And a couple of those seminars are about the two arguments you find on the federal income taxation page of wevgov.com. The two questions. Does the tax code apply to Americans? And number two, does the tax code impose a tax on the fair market value of services that I perform? Those two questions are the only object of the writing that you see on the federal income taxation page. On my YouTube channel, you want to watch the video called Key to the Code. That's about the question, does the tax code apply to Americans? And the other question, does the tax code impose a tax on the value of labor, is discussed in the video called Internal Revenue Ruling 2007-19. And what I'm about to tell you, while it is going to be very simple to understand, these are needles in a haystack that are several of many needles in the haystack that first had to be discovered, they had to be understood, and then they had to be compared to one another for relevance and gravity, and all the rest of them discarded. So the most important needles relevant to the particular question are the only ones that we look at. That in and of itself is a monumental task when you take into account the voluminous and complex nature of the tax code. It's monolithic. It's a behemoth. And I took the time, while as a taxpayer advocate from 1992 to 1994, after 3 or 4 years of self-study, I got a job at an institute in Tacoma, Washington that was trying to help people with frivolous filing penalties. And for my self-acquired knowledge, they thought, we need this guy on staff. He might be able to help our members. And so I went in August of 92 from working for other people 8 hours a day as an employee and doing tax law in my spare time at night to doing tax law 10 hours a day. And that's when all of my previously acquired knowledge organized itself right in front of me. That's when it all fell into place, when I could devote more time than just a couple hours a day to one question, a single question, and then I'll research something else on another day, something else on it, and spend many hours on the same question, going through all my acquired knowledge. Suddenly, I understood things about the tax code that are true today. And in 1994, I completed my treatise on the tax code, the differences between the code and the IRS. And here's the biggest one. Does the tax code apply to Americans? Here's how I argue it. It's at the top of the federal income taxation page of wevgov.com. It's in the seminar on the YouTube channel called Key to the Code. And if you want to follow along with notes in front of you, grab a piece of paper, 8.5 by 11, turn it on its side so it's long from left to right. Grab a pen. And you're about to find out the nature of the imposition of taxes. Everybody else starts in the middle of the code. Hey, can they lien me? Can they levy me? Gosh, this procedure they're using is sure putting the screws to me. Can they do that? And that starts you in the 6,000s of the code, Procedures and Administration, subtitle F. Why start in the middle of the code when the IRS is acting? They only act when there's a tax to collect that hasn't been paid yet. Start where the taxes are or are not imposed. You study the chapters that impose the taxes first. That's what I did differently. I started at page 1 of the tax code when I turned off the Patriot Movement in 1992. and never looked back. And I read through all the things that they apply to the individual. And here's the argument that came to the top. I have this piece of paper in front of me, turned sideways, draw a line down the center, so you have two equal halves, and draw a line down the center of each of those halves, so you have 4 equal columns. There are 4 chapters that concern the individual. When taxes are imposed, when they say what we owe as taxes are imposed, when I'm out there and I've filed the returns they want and I've paid the monies they want and they aren't after me, there are only 4 chapters in operation. From the left to the right. Chapter 1 on the far left. Income taxes. Chapter 2. Social Security, self-employed. Chapter 21, FICA, the Federal Insurance Contributions Act. That's Social Security employee. It's often referred to as the payroll tax. And one more chapter to the right, FUTA, Federal Unemployment Tax Act. Those 4 chapters impose taxes. Here's the chapter that I did not include because it doesn't even impose a tax. It creates a lot of problems and causes a lot of people fits, but it doesn't even impose a tax, and that's Chapter 24, the W-4 withholding method. It doesn't impose a rate of tax. It merely imposes the method by which a tax should be collected if it's imposed elsewhere. So I don't list Chapter 24. So I have these 4 chapters to deal with, and so I analyzed these 4 chapters. On the far right, Chapter 23, Federal Unemployment Tax Act, you have the definition of citizen in Section 3306J that says an individual who's a citizen of the Commonwealth of Puerto Rico or the Virgin Islands, parentheses, but not otherwise a citizen of the United States. Well, there goes that. That's not me. That's all. I know that's not my citizenship because the IRS says I'm a citizen of the United States, any person born or naturalized in the United States and subject to its jurisdiction. And this statute just excluded me. And I got a whole bunch of case law on how to interpret statutory definitions. They exclude what they do not mention. And this not only mentions me, it expressly excludes me when it mentions me. I'm not Federal Unemployment Tax Act, and yet every employer takes that tax out of every paycheck, don't they? It's part of Social Security. The Federal Unemployment Tax Act is the Old Age Survivors and Disability Insurance, which was a portion of the original 1935 Social Security Act. So I make the argument that that's not me. I move one chapter to the left. I'm now in Chapter 21, FICA. Section 3121E has the same definition of citizen. Same one. That's not me. And so I carry the argument into Chapter 21. And I'm in the Social Security Act. The Employee Social Security, 3121E. Now I move one chapter to the left, and I have Section 1402B in Self-Employment Social Security. Chapter 2 is only 3 statutes long, 1401, 02, and 03. And 02 is definitions, 1402B is definition of citizen. It doesn't tell you who is a citizen, it tells you who is not a non-resident alien, because they don't want to talk about it. And it says an individual who is a citizen of the Commonwealth of Puerto Rico, Guam, American Samoa, Virgin Islands, but not otherwise a citizen of the United States, shall not, for the purposes of this chapter, be considered to be a non-resident alien individual. Well, if he's not a non-resident alien individual, what is he? He's a resident citizen. And it expressly excludes me. So, There, I have 3 statutory definitions of citizen that obviously exclude me from Social Security, and I'm left with 1 chapter of the tax code. So first things first, I don't want to be double taxed. I want to know the nature of these taxes, and look what I found. I found statutes that exclude me because I'm a citizen of the United States according to the government. So I traversed right into their status, and that's where I got all my protections. Now I'm left with just Chapter 1. Chapter 1 is Section 1 through 1399, and I went to the statutory definition of citizen in Chapter 1. I went to the index. I went to the table of contents. I went page by page through Chapter 1, and it has no statutory definition of citizen. And from the other chapters, I can surmise that if Congress wants the citizen to pay the tax, they identify that citizen in a statute. And in Chapter 1, they did not. The government saw this deficiency, this inadequacy, and they wrote a regulation under Section 1 of the tax code, which is where we have all the brackets for the married individual filing jointly, separately, head of household, surviving spouse, single individual, capital gains, and trusts. And under that statute, which does not mention anyone's citizenship, they wrote a regulation that says, who owes this tax? Citizens of the United States. Wherever they live, you bet, anywhere they live, pal. And who is that? Well, that's any person born and naturalized in the United States and subject to its jurisdiction. Well, you can't do that with a regulation. They wrote in regulation what is not in statute. You can't do that. The 16th Amendment says Congress can lay and collect income taxes, and here you have the Secretary of the Treasury writing a regulation that makes me liable in violation of the 16th Amendment. That's how they dragged the tax code through that keyhole into the 50 states from Washington, D.C. They wrote that regulation. Everything is built on it. Everything. The entire IRS in the 50 states is built on the fact they wrote that regulation. Checkmate. Until they wrote that regulation, they had nothing that made a citizen of the United States subject to anything in the tax code, unless they might have been involved in some other activity, start a particular company, a life insurance company, whatever. Now they're in interstate commerce. Sure, federal jurisdiction. But I'm talking about the individual that sells their labor or reaps capital gains. Period.
Can I ask a question about that?
And this argument is checkmate. It's the first argument I make, which leaves just one other to do the heavy lifting, is a tax imposed on labor as a matter of having received gross income. So we're done with one argument. It's the first argument outlined on the income taxation page of wevgov.com. And it's in the video Key to the Code on my YouTube channel.
You're having a lot of
interference. The second argument
having
is
a lot of
this
interference.
one. Again, nobody teaches this. This is unique to my treatise, and no one has taken up the time to take these, except my students. No one has bothered to wield these arguments, and yet I've had great success with them on the criminal side. The next argument arises from the fact that the tax code says all property is a cost. And we know that they never let you say that your labor is your cost, even though it is property and you give it to another party under a contract to receive its value as compensation. How come when the tax code says all property is cost, how come the IRS doesn't acknowledge labor as a cost? And so I wield statute. The definition of income is right there in the tax code. It's called cost. Cost defines income. When you establish your cost, you have defined your income, which is the profit. Cost defines profit. Cost is defined in the tax code. Therefore, income is defined in the tax code. You got a whole movement out there that say income's not defined in the tax code because some judge said so. That's not good enough for me. I got a statute right here. This statute I'm the only one in the country in the known universes that teaches it. Tax Code Section 83, and on that federal income taxation page of wevgov.com, you'll have the quote from many circuit court cases, from tax court, and from IRS Chief Counsel Revenue Ruling 2007-19 that says Section 83 explains how property received in exchange for services is taxed. It governs the taxation of compensation. It provides for the determination of what is to be included in gross income when property is transferred to an independent contractor or employee as compensation for services. And the IRS doesn't even train on it. And they can't put on record a contrary interpretation of the statute to answer my memorandum. Isn't that funny? The statute that all of them agree. It applies to everything. It explains how to tax you, and we can't talk about it. Now pay up or we'll send you to prison. What's wrong with this picture? I'm sorry for any background noise. I'm not inside right now. I'm enjoying a nice sunny evening here in Seattle, if you can believe it.
No, you're good. You're good, David.
Good. And what that should also signal to others is that I don't need notes for any of this. This is all, it's my fingerprint. I could drink a quart of tequila and with the flu on NyQuil, and I could still tell you my entire curriculum. I have certain gifts, and I memorized all these things years ago, and it's second nature for me to crank out a memorandum about them. So back to Section 83, what is such a drag about the statute is the fact that while it governs whether or not you have gross income when you receive compensation, it doesn't say the whole paycheck's gross income. You have Tax Code Section 61A. It says, except as otherwise provided, gross income means all of it. Everything, from whatever source derived, including but not limited to the following items: fees, commissions, tips, alimony, dividends, gains derived from dealings in property. Everything. But it starts by saying, except as otherwise provided. Well, Section 83 is otherwise provided, and everybody agrees it's the explanation of how to tax my paycheck. And it doesn't say the whole paycheck's gross income, like the IRS does. It says, first off, it may as well be called paycheck. The statute is called property transferred in connection with the performance of services. When I turned off the Patriot Movement in 1992 and went back, started at page 1 of the tax code, I came to Section 83 and my world ground to a halt. And I said, if this applies to me, it's not being enforced. I went right to the law library and I looked up 70 or 80 cases about Section 83, and I found those cases that you see cited on the website, and the 2011 decision from the Second Circuit I found just a couple of years ago that say Section 83 is king. And it says, if in connection with the performance of services property is transferred, the excess over the amount paid is gross income. Which means before you can identify an excess that is gross income, you have to determine what the amount paid is. And the amount paid is defined in Regulation 1.83-3G. For the purposes of Section 83 and the regulations thereunder, the term amount paid refers to the value of any money or property paid. For the property 83 applies to. So the value of any money or property that I paid for my paycheck is an amount paid separate from the excess. I just now, with these provisions, I found a framework to place the value of my labor in the category of cost instead of the category of profit. Checkmate. With one statute. It wasn't placed on the books until 1969. Corporations came up with a scheme to compensate employees with restricted stock certificates that you can't have yet. You can't have them for 3 years. And so Congress wrote a statute to handle that type of compensation arrangement. And they said you can, if you you're going to get restricted stock or deferred compensation from your corporation, your employer, whatever, you can elect to have it taxed at today's value, or you can wait until they actually give it to you to pay taxes on it. That's Section 83B. I'm talking about Section 83A, which the courts say applies to all compensation, not just restricted stock plans. So it only hit the books in 1969, and somebody might say, well, look, it's so new, you can't say this is the standard. You're relying on the wrong statute. Well, forget the courts say it applies to everything. So I'm not talking about the wrong one, but another regulation under Section 83 says to determine your cost of property 83 applies to, apply Section 1012 and the regulations thereunder. 1012 is called basis of property. 1011 says the 1012 basis can also be known as adjusted basis. 1001 says the adjusted basis shall be restored to the taxpayer. What's left constitutes the realized gain. And those have their legislative history in the 1939 tax code, Section 111, 12, and 13. Checkmate. So a statute that didn't hit the books till 1969, sure. But the standard to compute or calculate cost under that statute finds its origin in the 1939 tax code. So I've done my work.
Hey, can I ask you a
I've
question?
read the case law on statutory interpretation, and I've read a bunch of other curriculums, and I know of a bunch of other findings. And in 1994, I wrote the book on Section 83. A year ago, I added 30 pages to it and published it. You'll see it there on weavygov.com. It's called Codebreaker, the Section 83 equation. Now listen to the damage I can do with Section 83. And this goes back to the comment I made about the internal operation of the tax code. When you don't know this statute, you don't know the tax code. Here's what it does. First off, Chapter 1, compensation for services. It's gross income. The IRS says, wrong. How does Section 83 operate in your conclusion? My paycheck, my fees, my tips, commissions, my sole proprietorship income, my self-employment compensation is gross income. They can't talk. They don't train on it. They can't answer the statute in my interpretation of it. The word any, in the 1990s, I lacked a particular segment of my research. And I went 5 times all the way to the Supreme Court on Section 83, writing for these clients I had in the early 90s. And by the October term of 1998, I had written and filed 5 U.S. Supreme Court petitions. 2 of those made it past the clerks to the justices before being denied. And in all of that litigation, the only way the government disposed of Section 83 was to say, well, hey, you didn't pay for your labor before you sold it to somebody, and so everything you received is a profit. You don't have a basis in your labor. And my argument was always, excuse me, but the regulation says the value of any money or property paid. In 2012, it says your cost is cash or other property. Where's your authority to exclude labor or any other property simply because I didn't buy it before I gave it away for compensation? And they'd penalize you for asking. They can't come up with a law that allows them to make that exclusion. And now I have 4 U.S. Supreme Court decisions where the government won, arguing that when you see the term any, it means all of it, unless the law provides for an exclusion. So the one argument they used against me in the 90s is basically have its lungs pulled out by these 4 Supreme Court decisions that the government won. And at the bottom of the federal income taxation page on weavygov.com, you're going to see a whole bunch of cases from 2013, 14, and 15 on the circuit level that cite one of those Supreme Court decisions about the term any. It's an accepted standard. It's everywhere. It's nationwide. When you see the term any, there's no exception unless the law makes the exception. They can't provide the statute or regulation that makes an exception to the statute, to the regulatory language that says the amount paid is the value of any money or property. There. Checkmate. Chapter 1. Now, take the notion that Section 83 applies to all compensation for services. Wouldn't that include Chapter 2, Social Security self-employment earnings? Social Security is an income tax. It only applies to the excess over the amount paid. And Section 83 defines the amount paid as the value of any money or property paid. Checkmate. Chapter 2, Social Security, free labor. Chapter 21, FICA. 3121A, wages, tips, wages and salaries. 3121Q, tips, compensation for services. Section 83 applies. Social Security is an income tax, and Section 83 governs how to tax those wages in Chapter 21. So they're stealing Social Security by depriving you of the provisions of the statute that defines citizen, and they deprive you of Section 83 to tax your pay under those chapters as well. It's a statute in Chapter 1 that reaches out through the tax code. That's why I named the manual Code Breaker, the Section 83 equation. Look at the damage I just did with one statute, Section 83, and I'm the only one in the known universes that teaches it. There's no excuse for that. It's right there in the tax code. And if anybody could read, if anybody first would take the time to read the tax code, they'll find a statute called property transferred in connection with the performance of services. And that doesn't even send them to the law library. Don't call yourself a researcher. And don't go out there experimenting with other people's paychecks, livelihoods, marriages, mortgages, estates, and liberty, saying you got a curriculum when you haven't even read the tax code yet. Look at how easy it was to debunk the entire movement, which doesn't move, by the way. It's a misnomer. But with just one statute, I just destroyed the IRS. It's gone. It has no occasion to even speak to us if the law operates. Now you go to your state income tax law, and it says your state gross income is your federal gross income. Well, how does Section 83 operate in your conclusion that I have gross income for the purposes of state tax law? Well, I'm checkmate. Look at how fast this goes by. I just annihilated the IRS. These two arguments are the reason they abandoned grand jury proceedings. It keeps coming back to me. Checkmate. From fourth grade through high school, if I wasn't high jumping and slam dunking basketballs, I was playing chess. And I compete. I know what's right and I know what's wrong, and if somebody screws with me, I get to the bottom of it. In 1977, I was slam dunking basketballs at halftime at the NBA games for the Pepsi Dunk team. I'm a 6'3" white guy. I was 175 pounds and slamming dunking basketballs like Michael Jordan. And 6'9" in the high jump, 48 feet in the triple jump, fastest bartender. You put something in front of me, and I'm going to knock the icing right off of it. And this is how the tax code works. I've been up against the government's best for years with this, and I've watched grand jury proceedings shut down because of those two arguments. There are many others. Like I said, I can prove they're stealing pennies, and I can prove they're stealing everything. And I've already briefed all of these impeccably. I write on par with the Department of Justice's best attorneys, and that's why I can't be part of the movement. Everybody thinks they're king, and the first thing I do is prove they don't know anything about the tax code, and if you did, you'd be out there helping people instead of getting them in so much trouble that they got to find Dave Merland.
Hey, Dave, we got a couple questions. Can we let them jump in real quick?
Yeah,
Brad, you want to go? All right.
Yeah, I'll jump in with a question. Yeah, this is Brad. Hey, I think I heard you say that on a couple times they actually changed the tax code as a reaction to some of the stuff you did. Maybe I misunderstood you on that. But did they actually do that with an act of Congress, or did they just decide they wanted to change it, and therefore does that make it positive law? Is any of it positive law? And I know some people make that argument, they don't get too far with it, but what's your take on that?
Yeah, because of the treatise, essentially a treatise that Lowell Beecraft wrote about what is and is not positive law and whether it matters, I don't even mention those arguments in my entire professional lexicon. Positive law. I never use that argument. I don't explore it, and it's not part of my knowledge base. The two changes that I'm referring to happen to be Treasury regulations that were rewritten directly because of my work. And this does not include the amendment that they made to the U.S. passport application because of my work in the early 90s. So two regulations, one was obliterated, the other one was totally revamped and put back into the code. And one of them is extremely telling. It was a regulation under Section 83 of the tax code. I found it in 1993. And in 1994, I raised a challenge to that regulation in several of my clients' tax court petitions. It was a you wonder how, when you look at that structure we laid out on a piece of paper in front of us, how do they use Chapter 24, the W-4 form, against Chapter 1? Where's the nexus between Chapter 1 and Chapter 24 that shows they ought to do me with the W-4 form in Chapter 1? It used to be a regulation under Section 83, and if you don't know about Section 83, you still ask the question, what's the nexus? Here was a regulation, 1.83-6, that said an employer, it didn't require the employer to do anything, it simply imposed a condition. It said an employer is required to deduct and withhold upon the payment of wages made to employees pursuant to the W-4 form to get credit for the wages as a cost of doing business. And I immediately saw three things wrong with that condition. First off, Section 162 freely permits an employer to get a credit for wages paid out as a cost of doing business. Secondly, how does Section 83 operate in your conclusion they owe an income tax on their wages that should be withheld by the employer? And third, at the end of the year, when I get my W-2 from my employer, it's got a box that says how much was deducted from my paycheck all year through the W-4 form. And then I go to my tax return, I fill this out, and it shows how much I made this year. Now go to the workbook and see how much tax is imposed on that amount. And I put that amount in the next box. And then it says, go to your W-2 form and look at how much you've already paid. And then you put that in the other box. And if this one's bigger than that one, subtract this from that, and we owe you a refund. Or if this is smaller than that, you still owe us a few bucks, pal. That's a Section 31A credit for your W-4 withholding that takes place all year. Under Section 31A, regulation, 26 CFR, Code of Federal Regulations is what that stands for, 26 CFR 1.31-2B says the provisions relating to the special credit or refund allowable under this section or shall apply to the special refund or credit allowable to any officer, employee, or elected official of the United States, a state, political subdivision thereof, or any agency or instrumentality of any one or more of the foregoing. Oh, that's not me. That's nobody in the country except federal public servants, basically, and yet every employee claims a 31A credit for the amount that they paid through their W-4 form, and they're not eligible. When you claim a credit for which you are ineligible, it's a crime. It's a fraudulent tax document, 26 U.S.C. 7206. It's a false and fraudulent statement on a government form, 18 U.S.C. 1001. And so my third challenge to this requirement or condition that an employer deduct and withhold was, excuse me, but if my employer withholds pursuant to this regulation so he can get a deduction for the cost of doing business in the wages he pays me, isn't it true I'll have to pay all those taxes again at the end of the year, or I'll have to claim a credit for which I am ineligible? This regulation is invalid for those three reasons. And in January of 1995, they rewrote it. It had stood for 15 years. Tax court had already ruled that all the regulations under Section 83 were valid and consistent with statute. I challenged them in the first briefs I wrote in my life, and it was rewritten the next year. And if you don't know about Section 83, you missed your chance to see the regulation that drew the nexus between Chapter 1 and Chapter 24. The other one is it's sweeping for anybody that has trouble with the IRS and their employer. At your employer's payroll department, let's say you file a W-4 exempt because Tax Code Section 3402N, as in nobody, 3402N says, notwithstanding any of the provision of this chapter, an employer shall not be required to deduct and withhold upon a payment of wages if there is in effect a W-4 exempt filed by the employee saying that they don't have a tax liability. But if you file a W-4 exempt, the employer notifies the IRS, and the IRS sends you a letter saying you better justify all your exemptions or we're going to have the employer withhold the maximum amount until you come clean. Well, how do they do that when you got a statute that makes withholding voluntary, basically? They wrote a regulation, 26 CFR 31.3402F2-1G5, subclauses 2 and 3. Subclause 2 said, if an employer gets a W-4 exempt, notify the IRS right away. And subclause 3 said, if we determine it's inaccurate, we'll instruct the employer to deduct and withhold the maximum amount until they come clean. There. With those two subclauses of that regulation where they obviously tried to bury their work. I mean, listen to it. 31.3402F2-1G5, subparagraphs 2 and 3. You know they were trying to make your eyes roll back in your head before you found how they destroyed that statute with those regulations. I included that regulation as one of the elements of racketeering and overt acts in the criminal complaint I filed with 80 members of Congress January 1st of 06. And in 2007, that regulation was removed. Checkmate. This is good work, okay? If I do say so myself, to be this precise and this knowledgeable about standard operating procedure versus the letter of the law. I can find little things they pull, things they do. I can prove they're stealing pennies, and I can prove they're stealing everything and everywhere in between. And so my analysis is the single most exhaustive and responsible and competent analysis of the tax code as compared to the IRS ever conducted.
Amazing.
And it was done by somebody who in 2011, the DOJ said, Mr. Merlin's a very intelligent individual, very smart indeed. Do you think they'd say that about anybody in the Patriot movement? They know I act totally independently, that I was done in 1994, and that I write these briefs in these criminal trials, and that I shut down grand jury proceedings. I've got radio shows. If you go to talkshoe.com, TALKSHOE, talkshoe.com, in the caller ID window at the top of the page, type in 59615, and it'll take you to my call archive, where a bunch of radio interviews are in MP3 format you can listen to, as well as a bunch of shows that I've put together. I taped a 45-minute show today about the healthcare decision that I'm going to post later on tonight or tomorrow to that archive. You're welcome to download all those shows, listen to the different angles I have on certain aspects of law and culture and politics. One particular one I'd like to share with you while we're in passing here is the NDAA, the National Defense Authorizations Act, that everybody says, oh, it's all over now. We can be held indefinitely under this act as Americans until the end of hostilities, and we know the war on terror is never going to end. And so without habeas corpus, they could lock us up, and we're all going to go to a FEMA camp because the Supreme Court didn't want to take up this decision by the Second Circuit. And what had happened was in district court, a couple of Americans and a legal resident alien that means from another country here in America, they're reporters and activists, and they said, this law, it squelches our free speech. It tramples on rights to free speech when it threatens us with prison for simply dissenting. And district court said, that's terrible. Let's issue that injunction. Sorry to bother you with this law. The government is hereby restrained from enforcing that law against these people.
Good.
And the government appealed the injunction to the Second Circuit Court of Appeals. And the Second Circuit Court of Appeals lifted the injunction. And everybody said, how can you do that? Look at what they can send us to prison without habeas corpus. What are you thinking? And they appealed to the Supreme Court. And the Supreme Court said, no, we're not going to hear it. And everybody thought, oh, that's Supreme Court. They sure put the screws to us with this one. Wow, what are we going to do? And you got PANDA Unite, PANDA, People Against the National Defense Authorizations Act. He skips one A, pandaunite.org or .com. It's an organization that wants a chapter in every state to abate or protest the enforcement of the NDAA onshore. Well, if you read the decisions closer, you see that the district court put in place an injunction. You shall not enforce this in the 50 states. And the government appealed it saying, but it doesn't give the president any authority to arrest and detain somebody that he didn't already have, and it doesn't apply to Americans onshore. And the Second Circuit said, you're right. This law doesn't apply to Americans in the 50 states, so you people that sued, you don't even have standing because it doesn't apply to you. And they lifted the injunction. The Supreme Court said, nothing wrong with that decision. We won't hear it. And everybody's up in arms when if you read the decision, you find out, but there's the court ruling that says it doesn't even apply to Americans. The government argued it that way, that it doesn't apply to Americans. And the government won. So it's over, and yet you got whole organizations out there thumping their chest. You got, what's his name, John Whitehead from the Rutherford Institute, an accomplished civil rights attorney, and he's got a chapter in his book devoted to the NDAA and how it spells the end of habeas corpus. Can anybody even read? And you'll hear an episode in my talk show archive at 59615 devoted to that. And I'm reading right from the decision of the Second Circuit, and everybody's up in arms over it, and just can't believe it. If you slow down a little bit and take your time and look closely at a lot of this, you'll suffer epiphany after epiphany.
Hey, David, I'm on the TalkShoe website right now. Maybe I'm not there. Could you repeat that? Because maybe I'm doing something wrong. What do I need to do to find your stuff?
TalkShoe.com. And at the top of the page, at their home page, I'm sorry, you might click on Live Now.
Oh, Live Now, okay.
But there's going to be a little box that appears at the top that says Caller ID.
Yeah.
Or Show ID.
Call ID, yeah.
Call ID, great. Type in 59615.
Right, that's
and hit
what I'm
enter.
Doing. Okay.
And it should come up with a show page for No Confidence. That's the name of my show.
Oh, there it is. Okay, it was the picture of a Star Trek guy. That was about Star Trek.
Yeah,
okay.
my nickname that I got in 1993 is Data. People saw that I barely need notes for any of this. In 1993, I was speaking to a group in Medford, Oregon, and it was an 8-hour Saturday, 8-hour Sunday tax course. And my notes for the entire seminar was one page of paper. Saturday was one side, Sunday was the other side, and all of it was numbers of statutes and regulations, no words. And they saw me teach off of that for 16 hours, and they nicknamed me Data. And so I go by that web name a lot of times. That's my avatar, Data from Star Trek.
I got you. Okay, so I did get it right then. Okay, so I've got it here. Thank you.
And other people have given me nicknames that I don't really care for. Nobody would, but I'll keep this one.
Now, there seems to be lots of content on here. Is there anything that you would recommend as a good starting point or kind of the
Thank you. Thank you very much. If you scroll down that list, 7 or 8 episodes, you'll see that Lowell B. Craft had me on the Micro Effect, where his show is, Liberty's Hammer, and he interviews me for a couple hours and has nothing negative when you know darn well that he spends a lot of time debunking the movement. And listen to me go back and forth with Lowell B. Craft for 2 hours about what is gross income, how the tax code defines cost and therefore defines income. And we get right into his historical research long enough for me to show him it's represented in current statutory language. So I don't need, it's nice to have the historical background and understanding, but you bring it forward into statute that exists today that the courts say explain how to tax a paycheck, and you needn't really go further back into the 1900s, early 1900s for the definition of gross income. That's a great interview to start with.
Well, I will. In fact, I'll probably download most of this, and yeah, I'm going to have a whole file and folder about this. I have a follow-up question regarding the withholding. So do you show or do you have anything on here, or how does somebody then amend or change their withholding at their employer, or what do they need to do regarding that?
I don't do civil. And again, you're dealing with a government that's willing. Okay, let's say if I were an employer and I said, listen, why am I withholding from my employees when the law says ABC? Do you know what their answer is? They're going to say, look, right over there, here's the binoculars. Look closely. You can see the grave marker of Dick Simkinen. He was an employer that stopped withholding on his employees, I think it was Arizona, and he went to prison, got out, and then blew his probation, got put back in prison, and died of a heart attack. You don't want that to happen to you, do you? And so there's the first deterrent. Second deterrent, you want to know whether or not you should withhold for your employees? Sounds like the IRS ought to set up an office upstairs from yours in your corporate building there to make sure you're doing everything right. They would be inviting the most insidious organism our government could concoct directly into the work site. They're not in business to manage your tax affairs. They're in business to make money. And so I preach to never involve your employer in your tax matters unless it's a job you want to lose. I concentrate strictly on keeping you from losing your liberty. That's what I do. Liens and levies, they'll still get your money. Pursue asset protection. People that can prove their trusts have gone to court and have been upheld as legal. Limited liability companies, there are other ways to diminish, maybe even altogether, your tax liabilities. And those are your only options. Other than that, start a home business, teach your children what you're doing so they learn entrepreneurialism. Start a home business, gather the deductions H&R Block says the IRS will allow, and at the end of the year when you've paid a certain amount for the year's end, you view that amount as the price of admission to the shouting match with your congressman. That's all you can do in America. And by congressman, I mean the Joint Committee on Taxation. Tax Code Section 8022 says the Joint Committee on Taxation is in charge, and so you bitch directly at them. Right now, the chairman of that committee is Paul Ryan.
What?
Listen to how responsible I sound compared to the others like Pete Hendrickson that says, hey, just file his tax return, you get all your money back. Yeah, in 2.5 years, you'd be levied with penalties and interest, and you might go to prison like James Back in Anchorage, Alaska, last December was sentenced to 16 months for filing Pete Hendrickson tax returns. But you're welcome to go do it.
Wow.
Those are the people that find me too late. And if you filed a 1099 OID, I can't help you. They'll supersede the indictment with other charges in Title 18, and now we're out of the tax code. I can't help you. You filed a false claim with the government, and the jury's going to look at you like you're from outer space. And I can't help you. That's what the movement is good for.
Gotcha. Okay.
You know what I think we'll do is we won't go into motor vehicle tonight, if you're willing to be held over to next week, maybe we can go into that in detail.
Well, very quickly, I can tell you what I have on wevgov.com in relation to the Motor Vehicle Code.
Sure, go for it.
In 2005, around October, when I had finished the largest part of my congressional tax criminal complaint to be filed January 1st of 06, in October of 05, I took a break, and I said, my Motor Vehicle Code brief, I got traffic court after traffic court that just runs from this brief. What the hell are they so afraid of? And I read that brief. It was like 17 pages. And I read it again. And I read it again. Read it about 10 times. And each time, one sentence stood out to me. It was a sentence from a 1961 Washington State Sessions Law. Chapter 1, Section 1X of the Highway Licenses Act. Said, definition of highway, any way, lane, street, road, boulevard, or other surface open as a matter of right to public vehicular travel. What highway are they talking about? I've never heard of a highway open as a matter of right. And I said that phrase again, open as a matter of right to public vehicular travel. I said, damn if that doesn't sound artful. I went to Google and I typed in open as a matter of right to public vehicular travel. I got 464,000 hits. It's in the law everywhere from coast to coast. In municipal ordinance, state statutes, state attorney general's opinions, a few appellate and Supreme Court decisions on the state level. And so I turned my 17-page brief into a 34-page brief by supplementing it with all these provisions from around the country on wevgov.com. If you click on the state or on the Motor Vehicle Code page, an explanation of this is on there in writing. On my YouTube channel, there's a video called Public Vehicular Travel that takes you through in audio and visual instead of making you read it like the website does, to show you that it's in the law everywhere from coast to coast, especially here in Washington State. So I was flush with provisions and references from all three branches of government here in Washington that say highways are open as a matter of right to public vehicular travel. The Motor Vehicle Code has never been written to apply to travelers. It has always only been applied through statutory language to those who use the streets as a place of business, commerce on the streets. When you look at the Motor Vehicle Code through that lens, it becomes clear that it's not an adhesion contract. There's no such thing. A contract is a meeting of the minds. That's the first thing the definition of contract will tell you. Well, if you didn't meet with the mind on the other side of that contract, it isn't a contract, because a contract is a meeting of the minds. So an adhesion contract, no such thing. It's either disclosed to both parties or it's not a contract. And you can't contract into something that doesn't apply to you. It applies to you whether you contract or not. It's a tax. It's a regimen for regulating the exercise of this privilege of using the streets as a place of business. The fact that you have a motor driver's license and tags on your car, those are simply trappings of the extortion and racketeering scheme. That's all it is. And so I don't presume enforcement is legitimate and therefore presume that I must have stepped into it somehow. I go to the law first to show that enforcement is legitimate, so nobody needs to presume a thing. And when people use this course, March 9th of 06, Kurt Riggin, the man whose research I built on top of for this, co-complained with me to the Department of Homeland Security, the Homeland Security Committee in Congress and the Department of Justice in a criminal complaint. When you look at the Motor Vehicle Code page, you'll see a link near the top of the page that says this complaint. Click on that, and you'll have the whole complaint and briefing of how highways are open as a matter of right to public vehicular travel. And when somebody joins that criminal complaint as a similarly situated victim and staples their traffic ticket to their joinder, that names their judge, their prosecutor, their cop, their mayor, their city or county council, whatever, whoever issued the ticket. You name them as similarly situated criminals in this affidavit or joinder, and you join them to an existing racketeering complaint before you even go to court on your ticket. And when you request a contested hearing, you ask that the officer be present at your hearing so you can cross-examine them about where the hell the right of public vehicular travel went. Here it is in state law. And what they typically do is tell the officer not to appear at the hearing so they can dismiss the ticket.
Wow, nice.
Beautiful.
It's statutory. You go to the law first and find out the limits of the act, and you find that enforcement is in excess. It's not legitimate, and so it saves you all these presumptions of adhesion contract. You use the zip code. You've registered to vote, and all the other stuff that comes along with the Patriot movement. And you learn, excuse me, just look at the law, take your time, read some case law. It's free seminars from judges. Read some case law about how to apply the law and find the limits of it. And in my instance, you don't even have to do, usually, your own research. I've already done the research. You simply have to learn the arguments. I encourage you to do research, but if you're in trouble, I'll give you the fast track with a baseline understanding that allows you to launch in your own defense while you get up to speed.
Nice. That's outstanding. So that is all up on your website as well. Everybody has access to it. Nobody should ever have another ticket again, ever. What if it's for like a DUI or something? Same thing? Totally works?
There's even courses for sale. You can find the Motor Vehicle Code Joinder on flash drive. It's a course on how to join your favorite public servants to the existing racketeering complaint. There's also a flash drive course on how to write and file citizens' criminal complaints. And then there's the pride of my course collection called Drive-By Litigation. It's as nasty as I can be on paper. In Shasta County, California, 2005, maybe 2006, no, 2005, a student of mine, he became a student because he liked the way I talked on conference calls. He goes, "You're talking a different game. Can we talk in private?" So we got in touch, and he liked the offensive nature of my approach because him and his wife each had 10 misdemeanor counts against them for building an awning on his mobile home without a permit out in the middle of his 42 acres, building a drain field without a permit, building a porch without a permit, all this ding, 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 little tiny stuff out of the prosecutor's office, and public nuisance. He was out in the middle of his 42 acres, so false charge after false charge, and he said he had already lost 50 pounds, and he was about 2 weeks away from picking up his high-powered rifle and blowing some people away. He was a vet, wasn't going to take it. And I said, calm down, let's look at this, and here's what I do. And in 8 months of litigation there in County Superior Court, my first time in a Superior Court on the criminal docket, we got 2 prosecutors fired. The judge retired 10 years early, and 2 members of the County Board of Supervisors resigned, one of whom he had been running against in the next election cycle had not resigned.
Bravo.
And I looked at the progress we made in that case, and I followed a certain process over the course of 8 months of criminal complaining, state and fed, putting the evidence in certain people's hands so that the prosecutor didn't know that he had filed complaints against them so they could be surprised by the bean counters for the county. And so we used information bottlenecks, criminal complaints, and certain procedures, keeping certain people in the dark until other people could spring the trap on them and fire them. And I looked at what that guy filed with the Department of Justice, and it made me jealous because his name was on it. I said, this is my student, and he's standing on my shoulders. I need something like this. So I wrote that criminal complaint to Congress about my tax treatise. But I took that process that took 8 months to master and or to conduct against these prosecutors, and I compressed it into what somebody might be able to do in about 3 weeks. And it's in that course, Drive-By Litigation. And it comes with, I think, like 10 or 20 hours of audio instruction, criminal complaints in Microsoft Word, and all the documents from his criminal case in Shasta County. And it's as nasty as I can be with the tools available to me in the system, totally in the box. So my courses are based strictly on law. I don't have a single theory, and we have so much remedy at every turn. It'll scare you to be an American, to see that they can't do any of this to me unless I'm ignorant. And when you cure some of that, suddenly they don't want to talk to you. Magic.
Wow. That is
Question.
awesome. Yeah, go ahead. Questions. Let's open it up.
I was probably in trouble like a lot of other people right now, and we all know trouble is a conspiracy. The courts are alleging that I owe them thousands of dollars, suspended driver's license, no plates, no insurance, near Virginia.
I know what game you're playing with that word near.
That's the best I know how to do. I'm in kindergarten.
Sure, and you don't have to do it. Let me first put your mind at ease. What you do is you research your municipal codes. You go to google.com or scholar.google.com, and you type in open as a matter of right to public vehicular travel, Virginia, and see how many ordinances and statutes you can come up with. And that's where you start your argument, to say, excuse me, but you've got me in the motor vehicle code. I need to know what evidence you're relying upon for your conclusion that I was engaged in commerce on the streets, because our motor vehicle.
But you've got the packet, or you've got something available, because, I mean, I suffer from PTSD and depression from an automobile collision, and I couldn't even remember going to court today when I got back in and I laid down and took a nap, and I started having nightmares. So I need somebody to kind of throw me a life preserver at this point, because I know they're going to try to throw the book at me.
Okay, I'll tell you what. Write down this email address. Tell me when you're ready.
Almost. Let's see. Okay.
I got it for you.
American Liberty, no, not my personal email address. This is company. AmericanLiberties.llc at Gmail. AmericanLiberties.llc@gmail.com.
Got it.
Send a request saying I need to consult with Dave about motor vehicles. And my promoter will get you on the phone with us, and I'll set you up, okay?
Okay. Do you know, or have you heard of Stan Prickle? And if so, do you agree with his work?
I know there's a couple people that are doing great work on traffic tickets, for instance, Ticket Slayer, and no one's got 100% guaranteed success. You're dealing with racketeers whose pension depends on their success taking your money. And so you can't guarantee success. I can simply give you the most statutory arguments. And what ultimately happens with those arguments, or with what I do or somebody else does, it's a matter of how badly they want you. And sometimes you have to settle for just a reduced sentence, reduced fine, avoid jail, pay a fine, pay court costs but not a fine, anything to keep your insurance from going up, to keep from going to county jail, to keep from getting a license suspension. If you can soften the blow and get the knee pads on.
But I'm already on a suspended license, and when they pulled me over for no plates, so I'm just wondering if I can get it kicked out because of the probable cause fact that Rodney Rouzan talks about with the California statute. I don't know if you're familiar with Rodney's work.
I'm not sure what he does, so you have to choose who you're going to go with. I'm not looking for somebody faithful to me. I'm looking for people to win their cases, no matter who they use. So I'll consult with you, and then you can make your choices, and I'll give you what I can to keep you out of this trouble. But I have my approach, and it's a battle that I've chosen not to wage, and so I have plates. I have a driver's license, and then I'm off that radar while I do this other work.
Okay. Thank you.
Of course.
Anyone else?
I can say.
Well, the previous caller, Dan, mentioned the guy Stan Preckle, who's out of Washington. So that's not a name that you're familiar with.
No, I don't get out much in state. All my work is on the internet, and I've really stayed within the income tax front. So I don't know the lay of the land regarding other areas right now.
Okay, very well, very well. Well, this is great. I mean, I love this philosophy that I'm hearing of going on the offense, and I really relate to your comment about being a chess player, because I'm a decent chess player, but I always had a buddy who I always played with, and he always seemed to be able to kind of back me into a corner because I played defense, and once I learned to start going offense, he could have me way pinned down in the back, and I could come back and put him in check or put him in danger. And once I started going on offense, I started picking him off, and I'd usually end up winning those matches. So I say all that just to say I love this philosophy of going on offense and getting their back against the wall and back on their heels as well. So thank you for that.
I'll tell you something about chess. I told you that 4th grade through high school I played. I have not touched a chess piece since my senior year in high school. And it's because after I'd play a couple games, it would take me 2 hours to settle down. I'd get the cold sweats. I'd be digging my fingernails into my palms and clenching my teeth. And I wanted to win that badly. And in track and field, I kicked everybody's butt. And when it came to chess, I beat people on the chess team as a high jumper on the track team. And so I'm serious about stuff. But chess, it just got me too wound up, and I had to quit because it takes up 2 hours after I'm done playing where I can't really think about anything else. So when you listen to what I do with law, I'm a super competitor. I hate to lose, man. And when I compete, the only reason I'm on the field is to make the other guy look terrible. It's all I want to do when I compete, and the government got my goat, and it's what I've been doing with government since like 1994. I've been wiping the floor with them. So, and Louis Ewing is the same way.
Yeah. Well, I'll invite you then to kind of take a good look at the divorce court, and maybe you'll come up with something equally strong divorce or not.
Oh, that's good.
Yeah.
Brad's got a good personal story about that. That's why I'm passionate about that.
Yeah, the he said, she said is always up to the discretion of the judge, and that's why I like a statutory argument, is that it leaves the judge a lot less room. So count me out, and best of luck on that.
Okay.
Back to the drawing board, Brad. Any other questions, comments we want to fill in with?
Well, this is Wayne. I just have one comment, if I may.
Yes.
That's due to other people might be interested in it. I'm not pushing it, but my favorite site for learning contract law is River. freedomriver.wordpress.com /parts-of-a-lawful-contract/. I'll repeat it. freedomriver.wordpress.com /parts-of-a-lawful-contract/. And I yield.
Excellent,
My favorite place for contract law is American Jurisprudence Second, the volume entitled Contracts, Section 1 through 360.
Excellent. Thank you for that.
Repeat that. I didn't get all that. I was writing that down.
American Jurisprudence Second. It's an encyclopedia of law. There's It's alphabetical. You go to the one entitled Contracts and read section 1 through about 350, 360.
Got it. Okay, got it.
So
And
how's
the
your wife?
case
How's your wife about all that reading and all that? That's a different. Not many guys are into that, so that's really great. We're all the people that are willing to do that, those kinds of things. That's our excitement on a Saturday night. Go ahead.
Yeah, it's sadly that's what it takes for law.
Yeah.
The sad part about it is not the reading. The sad part about it is that if you don't, you'll be taken advantage of, and that's profoundly un-American. It'll happen at the hands of our servants, and that's totally upside down. But that's what requires you to take up the fight and put your feet on the ground and start running.
Awesome. I thought I heard somebody else. Is there somebody else that wanted to say something?
Yes, up there in Washington, David. Are you familiar with Dave Darby and Hartford Van Dyke?
No, I've heard of Hartford Van Dyke, but I've never studied any of his stuff. Nowadays, and he was popular when I heard his name for commercial liens, and those will get you indicted, 18 U.S.C. 1521. And so I've never really had the occasion to, since I'm on the offense and I know the basis of all these modes of enforcement, I really have my path chosen for me by the language of statute, and so I don't really need the process taught by anybody else when I, in fact, know and can prove I got the right to arrest every one of these people. And so there's not much that can really interest me. So I'm moving away from law, as a matter of fact, and I patented a product April 1st, and I'm moving toward having that manufactured and sold worldwide. So I'm moving away from law, but I've got my courses if somebody's interested.
I have
no court that you stand on?
I'm sorry? What?
The court that you stand on, you created yourself?
Courses.
Oh, the courses that I offer, it's what I do.
The court. Whose court are you in?
I'm in the traffic court they hear traffic tickets in. I'm in U.S. District Court where they take federal defendants. I'm in the grand jury that the DOJ convenes. I don't make any argument against any particular court unless it's obvious, even to attorneys. I argue inside the box all the time. That's where my tools are, so I don't really need to get exotic.
Excellent. Okay. Thank you.
If you want information for Hartford and Dave Darby are friends, I have the information. I have his phone number and all that if you want contact with Hartford or Dave.
Okay. Well, Randy, it sounds like we've beaten this one to death.
Well, is there a topic that you want to go into next week? If so, I'll hold it open for you for next week. If there's something you want to go pretty deep into.
I described to you what I can do to the Social Security Act, and I alluded to the fact that the Patient Protection and Affordable Care Act, half of it is an amendment to the Social Security Act.
Okay.
Half of it. And so screw the Patient Protection and Affordable Care Act. It's part of the Social Security Act. It doesn't even apply to Americans if I'm a citizen of the United States. You should have me on about the Patient Protection and Affordable Care Act.
Okay.
I'm probably good for about an hour on it. There's other challenges I've not alluded to this evening that I know everybody will find very intriguing. And since the second challenge to the Health Care Act has now failed, it's really time to mount another one, and you're going to find it's profoundly simple, and it kills the bill.
Awesome. Okay, so why don't we have you on 9 o'clock, if that works best for you, 9 o'clock next week on Thursday.
For you, I'm easy. Send me an email.
Awesome. You got it. 9
But we need a whole Thursday. We need a whole Thursday with him. We need like a follow-up. And Dave, what can we do? Because, I've most probably already sent out 30 text messages to people across the country while we've been on the call tonight, telling people about this call that they need to be on it. What can we do right now to, is there anybody that we can call or contact to just kind of spread this message? Or
for sure, give his website out with his video.
Yeah,
go ahead.
WeVGov.com has a link for subscribing to email from my promoter, and go to TalkShoe 87488, and I'm there with my promoter 2 times every week. Those calls are recorded, 87488. And my own archive, No Confidence, is at 59615. Start listening to those shows. Contact that email address. We'll put you on a list to receive updates when the calls are going to occur. If there's anybody else out there with a radio show that wants me to appear for an interview, I'm game.
There you have it. And we'll have him here Thursday next week. He's already kind of thrown the bait out there about some, juicy stuff he wants to hit. So make sure you guys are inviting people to the call Thursday next week. Of course, we're on at 8 o'clock, but we're going to have him on at 9. And, David, you were a real blessing to all of us. Thank you so much for coming on. And I know everybody loved what you had to say because we didn't lose any callers on this. So if somebody fell off, we can right back on. Yeah.
I speak the way I speak about others because their victims find me when they're losing their liberty, their marriages, their mortgages, and I don't have a bad attitude about the movement. I've got the proper attitude about the movement. When I can prove that they just haven't done the work and they don't have a respect for the complexities of the law, you got to say something so that other people don't step in that trap.
Well, I would say that that's a matter of personal opinion. But, that's everybody's entitled to their own process.
Yeah, he's got some good stuff going on. I wanted to make sure too that everybody subscribe to our 42 action. Eileen, if you're on there, throw out the page. Eileen, unmute your line.
Hi, Randy.
Right. There you go. What is it? Everyone meet my assistant, Eileen. She's the most amazing assistant on the planet. Go ahead, Eileen. What is it?
Hi, everybody. No, it's 42 Action on YouTube. If you just go to youtube.com and type in 42 Action, you'll find the YouTube channel. It's also linked with Google+, and I put the law calls up usually within 48 hours. So
this repeat will be not only you can call in and listen to it here, but she'll have it broke up by the 2 hours, the first hour and the second hour, and she'll have them up within like she said, 48 hours, and we'll have this labeled so you'll know which call it was. It'll be on YouTube. So thank you, Eileen. And if anybody needs anything, I gave out the number earlier for the first hour that will always ring to Eileen. So if there's anything you guys need and I've been non-responsive on the email, make sure you call the phone number and get Eileen, and she will get a time set up. And that, again, was 844-447-2386, extension 704. Thank you, David. Thank you, Eileen. Thank you to all of those that gave us some input. And we'll see you guys next week, Thursday, 8 p.m. Eastern Standard Time.